All right, Edward Valdez.
Yes, Your Honor.
Just a little background on this case. Mr. Valdez was approved for pretrial diversion. I do have the signed agreement.
Well, what I can tell you, based upon the new rules on a bond for him, because does he have a remand without bond because he didn't appear?
I believe so.
All right, so I understand that he's applied for PTD. So, I'll agree to a bond reduction. But have you conferred with the state on the amount?
Judge, this is a little confusing because he's been approved for PTD. If he was out on bond, he'd enter the contract. So if he accepted a probation, wouldn't he be released?
Yes, but here's the thing. There are new rules with regards to setting up bonds and when I can set for PR bonds and when I cannot. And this is the case that legally I cannot. And let me explain something to you. So if I were to give you a PR bond and legally you're not eligible for one, and if you were to commit a crime, guess what? I can be sued. And I would be responsible for that suit because I violated the law by giving you something that you're not entitled to. Now, do I understand that they're giving you, offered you a pretrial diversion? And so that means that probably you should get a PR bond. I understand that, but the problem is legally you're not supposed to receive one. So if you'll confer with the state on some sort of bond amount, I will give him a low bond amount, but I can tell you it's not going to be $1.
Whatever you want to give him, whatever.
I mean, if you'll confer with the state on the
they
amount.
really don't care.
Well, no, this is State of Texas versus Edward Valdez. So they're supposed to give their opinion on a bond amount.
Okay, let me get.
All right, just have a seat.
Amen.
All right, who's here, Mr. Small?
I'm here, Judge. I'm present.
Okay, so on this case, what is the update on the Fed?
I have a new order, Judge, from the federal court. Last time we were here, he was supposed to have taken a plea in September. They have continued that. Last plea deadline is now December 4th, 2025. Yes, they're in no rush.
Okay, let me go on the calendar.
Mr. Small is still living large in big boy custody.
Go. All right, so then what we'll do, we can set this. Are you all available December 15th?
I would think so, Judge.
All right, I know that's getting close to the holidays for some people. All right, so we'll recall it for December 15th.
Hey, Judge.
And if you know before then that it's been reset, just
Okay.
send me an email.
Okay, December
15th.
Thank you very much.
Thank you.
I'll take care.
You too. Ray Guthrie,
Good morning, Judge.
good morning. Good morning. Thank you for dressing appropriately for court. All right.
Oh,
Where are we on
No,
discovery?
I'm sorry. I'm hard of hearing, Mr. Chairman. I'm sorry.
Huh?
He's
I'm
hard of
here to
hearing,
hear you.
Judge.
I'm sorry.
No problem.
I believe discovery is there, Your Honor, but the defense are still going through it just to confirm that fact based on what we talked about.
Yes, Your Honor.
In that setting, we should be able to enter that discovery on. But also the state does need to go on the victim, so I intend to do that and have that done in office and residence.
All right. I need a 30-day reset. All right, we'll have you back on December 4th. At that time, state, you need to be prepared to tender an offer. All right, thank you. Once you sign the reset form, you're excused.
Okay.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, are you all ready on Valerie Marino?
Ready, Judge?
All right,
Good morning.
good morning. And did she pay the 500?
I have
the
money order.
She brought it, Judge.
All right. And state, where does she need to take that?
The money form, the first floor and then I.
Oh.
Form for you. Section, like the X-ray machines.
Oh, in the front. Oh, yeah. Perfect.
All right, the court is calling 2025 CR 006933, State versus Valerie Marino. Can I have parties announced?
Travis Kettner, Your Honor, for Ms. Moreno. We're ready.
And are you Miss Marino? All right, we're here for sentencing. According to your plea bargaining agreement, there's a restitution of $1,764.08. Um, and this cause number and also the defendants must pay that amount as well. And when I say I pay that amount, of course, it's only going to be a total of $1,764.08. But if for some reason they're revoked or they don't receive probation and they don't pay that, you'll have to pay it. Do
Okay.
you understand?
Yes, I understand.
All right, so I have a few questions for you. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. Who is Valerie Marino to you?
Me, myself.
Oh, sorry, Amber Marino.
My sister.
Okay. And do you have any children?
I do. I have 4.
And what are their ages?
My 2 oldest are 9. My third is 5, and my baby just turned 5 months.
And do they live with you?
They all.
And what do you do for a living?
I'm currently a stay-at-home mom, but I'm back into school, so I'm going to dental for a dental assistant.
And when are you starting that?
Today, actually,
Ah.
I'm starting night school tonight.
Oh, what time?
At 6 p.m.
So while you're here, who's taking care of the children?
Their dad. Well, their stepdad. So, well, the youngest, because the other 3 are at school. So.
And so is he the stepfather to the younger child?
The 3 oldest ones, but he's the dad to the youngest one.
Okay. And have you ever had any type of mental health issues in the past?
No.
Have you ever been diagnosed with any type of mental health issues? Any drug use in the past?
No. I do drink occasionally though. So.
Right. So while you're on probation, you're not allowed to drink alcohol.
Yeah.
Those are the rules. All right. This is what the court, oh, any questions? All right, state you may be excused. All right, this is what the court will do. The court will sentence you to 3 years deferred adjudication. There's $1,000 fine that will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, or a full-time enrollment in school. There's to be no employment as a home health care provider or with minors. There's to be no contact with the following address: there's to be a remaining balance of restitution of $1,264.08.
Judge, I don't mean to interrupt you. She actually brought $600 to show good faith to the court. So I wanted to be sure that
Thank you.
correct number there. Thank you.
You're welcome. So it's to be $1,164.08. There is to be a payment today of $600. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the court will deem the community service satisfied. There's to be no contact with Richard Serta, and that's with a C, and probation. That's who the restitution is to go to. And you're jointly and severally liable for $1,164.08 with the co-defendants and cause numbers 2025 CR 006931 and 2025 CR 006934. And there's to be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And I'm sorry, one more thing. Who is Roman Daniel Villarreal to you?
Brother-in-law? That's my sister's boyfriend.
Okay.
Yeah.
All righty. Good luck to you. And
Thank you,
we can
Judge.
go off
Thank
the
you.
record in this court.
Thank you.
Communication is key.
Oh, I'm sorry.
All right, that's okay. Communication is key. If you have an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to the court,
Okay, that's fine.
but don't disappear, okay?
Thank you.
All right,
Thank
good
you.
luck to you.
Thank you, Judge.
You're welcome.
Yes.
Is this a motion to revoke?
No, it says if they wanted to reset. Yeah.
So it's not a motion to revoke?
They wrote on here, reset, bond. David Cortez.
Ms. Abrams, is he on probation? David Cortez. Because this cause number is from 2019.
Yes, sir. Another case. The other two appeared. We have a bond agreement, EA. wants you to-
So is he on probation or no?
I'm sorry, I'm trying to get,
Oh, no problem.
David Cortez Jimenez.
Yeah, page 8. So what is the history of this? Let me look at the history of this case. I don't know why this case is so old and it's on the docket.
Yes, sir. He was for. I think this issue is one.
All right. Oh, so he's been missing for 6 years?
Apparently, he was on, he didn't know he had a court date. So he just missed it in the issue one, got picked up for classified.
So there's been a warrant out for him for 6 years? Oh, okay. Got it.
He's had immigration issues, so I probably think we talked to immigration lawyer.
Mhm.
We get him on bond, immigration lawyer.
Oh, so I see where the bond forfeiture was issued in 2020. All right, do you have a motion?
There was a motion on file for the bond.
I looked for everything and I didn't see it.
All right, court is calling 2019 CR 6016 State versus David Jimenez. Can I have parties announced for the record?
Mark Rose for the defense.
All right. And are you David Jimenez?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, if you'll state your name for the record.
Pamela Payan, Payan.
All right, so we're here on a motion to, it says to modify bond conditions, but you're asking that a bond be set?
Yes, Judge. It was 7,500 before, but they're gonna increase it to 10.
All right, State, have you had a chance to review the bond?
Yes, Your Honor.
All right, defense, do you have any witnesses?
I don't, Your Honor. It's an agreed order. So
Well, I mean,
he's, we're fine with the bond amount, Judge.
but I need to know, I know you said you all have agreed on a bond, but to set a bond, I need to know, one, if it's an appropriate bond amount for him. All I know from what you have said off the record is that he's been missing for 6 years.
I can ask him a question, Judge. My witness is
All
there.
right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
David Fernando Cortez.
All right, defense, you may proceed.
Thank you, Your Honor. May I please report?
Yes.
You are David Jimenez, correct?
Yes.
And before you got arrested, you had a job, correct?
Yeah.
Okay. How much?
Counsel, if you could speak up so that the court reporter can hear.
Oh, I'm sorry. How much were you making, let's say, per hour?
Pues depende, pues, de 10 a 17.
So it depends, anywhere from 10 to 17.
Okay, and were you working full-time?
Sí,
Yes,
Okay, and if you're out on bond, will you still have that job?
sí.
yes.
So it's safe to say that you make about how much per week?
Puede ser de 600, 800, de 500 a 800. Depende del trabajo.
So it depends on work. So it could be 600 to 800 or 500 to 800.
Do you have a residence here in Bear County?
Sí,
Yes,
Okay. Is it a permanent residence? Do
sí,
you have
yes,
family in Bear County?
sí.
yes.
Who do you have, like, what's your closest relative in Bear County?
Con los hermanos.
2 brothers.
Okay. Do you travel out of, state often?
Sí, no seguido, pero sí he viajado.
Yes, well, not often, but I have traveled.
Okay, do you have any reason to leave the country?
No,
So if the court is to set a bond, let's say at $10,000, is that a reasonable amount of bond for you?
está bien.
That's fine.
And you have the ability to post a bond on that amount?
Yes.
Pass witness.
I don't know.
All right. Does anybody want to ask where he's been since
Oh, for the,
2019? And why he didn't appear for court?
let me ask that quick. Did you know you were charged with an offense in 2019?
Sí, y
Yeah.
el abogado que yo tenía me dejó solo en la corte.
Yes, the attorney that I had left me on my own report.
Okay, did you appear for court, on the day that, you alleged that the failure to appear occurred?
Perdón,
Sorry.
Were you in court and your attorney just left you there?
sí,
Did you get a reset form? Did you sign anything to reset?
no. Esa vez estuve en corte, llegué temprano. A la hora de lonche,
Ujú.
la jueza me habló, me dijo que dónde estaba mi abogado. Le dije, no ha llegado. Dijo, ve afuera, habla, habla por teléfono con él y dile que venga, que lo estamos esperando.
So that day I showed up early and the lunchtime came and then the judge called me over. She spoke to me and she told me where my attorney was at. So it said he still wasn't here. So said to step outside and call my attorney and ask him why he still wasn't here.
Y me dijo, no vayas con él, habla por teléfono. Cuando yo hablé por teléfono a la oficina, me dijo la secretaria que estaba en camino. Me devolvió a la corte y después de volverme a la corte, estuve toda la corte, nunca se presentó el abogado, yo estaba, ok.
So then she told me to go and call him, not to go where he was at. So when I called his office, the secretary told me that he was on his way. So I came back inside the courtroom, I waited and he never showed up.
Y luego la jueza me habló, me dijo, ¿dónde está su abogado? Le dije, no llegó. Dijo, ahora vaya a su oficina, vaya usted a su oficina, ya no le hable, vaya a su oficina, dígale que venga y saque un día para la audiencia con usted, que les voy a esperar. Y
So then after that, the judge called me. She asked again, where's your attorney? I said he didn't show up. She said, don't call him, go to his office, just go to his office and tell him that he has to set a day so he can show up with you in court.
fui a la oficina y la secretaria se estaba yendo. Me dijo que está bien, que iba a hablar con el abogado, que no había venido porque había tenido un asunto familiar.
So I went to the office, the secretary was about to leave and I told her and she said that it was fine, that the attorney hadn't showed up that day because he had a family emergency.
Y entonces al siguiente día yo fui a trabajar. Cuando acabé mi trabajo, fui a la oficina del abogado. Estaba el abogado ahí y le dije que por qué no se había presentado en corte.
So the following day I went to work. When I got out of work, I went to the attorney's office. The attorney was there and I asked them why he didn't show up for court.
Él me dijo, el que no fuiste tú, ya tienes orden de arresto.
And what he told me is that the one who didn't show up was you and you have a warrant for your arrest.
Y le dije, si yo fui a la corte, y le dije a la secretaria, dijo, no, la corte fue hoy. O sea, que fue el siguiente día.
So then I told him, yes, I did go. I spoke to the secretary. He said, no, your court was today, so that means like the following day.
Él nunca me dijo nunca me avisaron que había puesto la fecha para el otro día. Yo fui a las 5 de la tarde un día antes, y
So I was never advised that the court had changed to the following day. I just went the day before and I thought it was.
en la esposa del abogado, también es abogada, estaba ahí. Cuando yo que tenía una orden de arresto, me dijo, yo te la quito a ti por $500.
So when I went there, the wife, the attorney was there, who's also an attorney. And she heard that I have a warrant for my arrest and she said that she could get that removed for $500.
Okay, and I paid $500 en ese momento. Y dijo, mañana vienes. Al otro día yo fui y cuando acabé mi trabajo, yo les dije que qué pasó cómo estábamos con eso.
So then I paid her right there and then the $500. Then she told me to come back the next day. I went back the next day after work.
Okay, so you did show up before, correct? The day of your hearing?
Sí,
Yes.
debe estar representado.
Was it this judge?
Fue aquí, fue en esta misma.
It wasn't the same.
Okay, so it was a different judge, but you did see the judge, correct?
La mera verdad, no recuerdo no puedo echar mentiras, no recuerdo si fue ella.
So honestly, I don't want to lie. I don't recall if it was her or someone else.
Okay,
Pero-
do you speak to anybody like a bailiff, like one of these officers? And then check in somehow?
No, de hecho debe de estar en la computadora donde yo me presenté y no vino pues.
Okay.
No, so it should be in the computer.
El gobernador, el abogado,
It should be in the computer that I showed up without the attorney.
es el 2019, no sé qué, no me acuerdo qué mes, pero yo vine aquí a la.
It was in 2019. I don't recall which month, but I did show up to court.
Ask for this.
All right, any questions? All right. So what bond are you recommending, state?
He's recommending a bond of $10,000, based on one DWI in 2011 and then a second in.
No tengo idea.
I'm sorry, is there something he wanted to say?
No, he's asked how much it was.
All right, your bond will be set at $10,000. There's to be regular random UAs.
Okay.
And the fees will be waived. All right.
Okay.
Normally, this needs to be recalled in 30 days. All right, give them a reset form, please. No, that's for disposition. All right, is there anything else?
No, Judge, thank you.
All right, so on that date, December 4th, this case will be set for trial, or you all will have reached a plea bargain agreement.
I think so, Judge. We have a clear and file. He just needs to talk to immigration. That's it.
All right,
All right,
thank you.
Thank you, Judge.
All right, you're welcome.
Set for December 4th?
Yes,
Thank you, Judge.
you're welcome.
Thank you. Gracias.
All right, Luis Flores. Luis Flores, who's the attorney?
Judge, we're just here for sentencing. I think there was a restitution issue that needed to be cleared up.
All right, and has that been cleared up?
She notified, I don't know what the answer was.
Okay,
For you.
Hey, Judge,
Hi.
I did reach out to the complainant. She did tell me she would take the vehicle for an inspection, but since hasn't gotten back to us.
okay. All right, the court is calling 2025 CR 008012. State versus Luis Flores. Can I have parties announced for the record?
State.
Robert Gaona for the defendant.
Louis Flores.
Right. We are here for sentencing. You entered a plea on September 2025. You entered a plea of guilty. And the reason for the late date of sentencing is because I believe the state, you need to get some information with regards to restitution.
Judge,
And what are the results?
the results of that, judge, are that we would be waiving restitution. The complainant hasn't given us a definite.
Then the next thing we need to address is the TAP evaluation. Have both parties had a chance to review the TAP evaluation?
Have not, Judge.
All right. Counsel, do you want to address the results of the TAP evaluation? They're recommending inpatient treatment.
Yes, Judge, and I'd ask this court to give him a chance to try outpatient first. See if he can do what he said he's intending on doing in exchange for your probation.
All right, my issue is that this is a DWI with a child under 15, major accident. The reason why he doesn't have any restitution is because no restitution has been provided. So he is either going to end up going, based upon the TAP evaluation, he's either going to end up going to SATF, or either he's going to be in the felony drug court. And what I can tell you is that it is rare that out of the gate, TAP evaluation, TAP recommends inpatient treatment.
Okay.
So you're going into custody today. And what I can tell you is that felony drug court will put in the request for a referral to felony drug court. They'll have him interview before the week is out. But you need to be honest with them about your alcohol issues. If you're not honest with them, you know what's going to end up happening. They're not going to accept you into the program. And then you're going to end up going to SATF because that's what TAP says. Felony drug court is an intensive program, but it's a great program. Okay. All right. This is what the court is states. You may be excused. All right. As previously stated, the court found you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's to be 10 days in the Bexar County Jail as a condition of probation. There's to be a referral to felony drug court. That's to be done in custody. If not accepted to felony drug court, then it will be SATF. There's to be $60 restitution to DPS for testing. There's to be no restitution. Ignition interlock for half the term. DWI intervention. VIP live. 2-year license suspension. 200 hours of community service restitution. 100 of those hours will be waived upon completion of parenting class. The remaining hours for every sober support meeting you do, an hour will be deducted from your community service restitution.
Judge, when you're done, he has a request.
All right. There's going to be field visits 1 time per month for 6 months. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home health care provider or with minors. Probation, is there anything else? Yes, you had a request.
Yes, ma'am. My wife's legally blind right now, ma'am, and I'm the only one to help her with the kids. We don't got no support, ma'am. I don't know how she's gonna do it. I mean, I'm the sole provider of the household, ma'am.
I understand that, and I understand what you're saying, and I want you to know that the problem, though, is that you're not a help to her or to a help to the children if you have an alcohol problem. And I mean, that's why we're here. And I don't know if you've read the police report recently, but the police report is very bad. And you were extremely intoxicated. And easily, your child could have been killed or you could have killed someone else. So you're not of help with that. And I don't know the reason for your drinking to intoxication. I don't know if because you have a lot on you. I understand. You have a lot on you taking care of the children, a lot of you taking care of the wife, a lot on you with work. And maybe that's why you're self-medicating, but you're not going to be any good to them if you continue on this route, because either you're going to end up having some kind of alcohol related disease, or either next time you're going to be driving and you're going to kill somebody and then you'll be going to prison potentially. So what you need to do is you need to be 100% honest with felony drug court. As I said, today is Monday. They'll see him before the week is out. I'm going to get the request from Miss Abrams. Probably within 5 minutes, I'm going to sign it and she's going to email them and let them know to do an expedited one.
Appreciate it, Judge.
Right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you need to speak to an attorney. Do you understand? All right. And counsel, I'll make sure that they're aware of his situation and to do it expeditiously.
Thank you, Judge. I appreciate it.
All right. Thank you. All right. Good luck to you, sir. Mario Vargas. All right. So what is happening?
Well, Judge, we had a motion to revoke his probation and it was denied, but he was sentenced to 180 days in Bear County Jail, day for day, and then also go to safety. He's been there 45 days and he's considering taking a plea offer. Well, he could do either probation, they're offering probation. But if he does that, he has to wait for beds over in safety. And he's a father of 5 children and a wife that is having a hard time. And we want to see if the court can offer us some suggestion as to maybe staff evaluation, because I think that this time in jail has been an eye-opening experience for him.
I don't think so. And let me just tell you the reason why. You're on probation for DWI and you picked up a new DWI. So you're going into inpatient treatment. Now, the only other suggestion I can make, if he wants, he can refuse inpatient treatment. They'll file a motion to revoke and then we can hear that.
Well, it's just, I mean, he doesn't mind getting the treatment. But I think the court can get a better handle if there's some type of evaluation on.
No, he needs to be in inpatient treatment.
But he's been waiting, and even after he does the time, he's got to wait. Some people have waited 4 months.
I mean, we'll see where we are. But the problem is you're on probation for a 3rd-degree felony, and that's a DWI. And then you pick up another DWI.
Yes.
It seems to the court that you need inpatient treatment because there's nothing working.
And he wouldn't mind that, but the thing is the waiting.
Well, I mean, I understand what you're saying, but he's in jail now waiting because there was an agreement. He has 180 days as a condition of probation. So once that's satisfied, then he'll go to inpatient treatment.
But he has to wait and no telling how long. And so I don't know what, can we get us a reset so that he can consider the options?
Oh, sure. But I will tell you this, if we put a reset in there, if a bed becomes available, they're not going to take him because he has a reset. So
won't. Exactly.
if you want to, you can just when you think time has lapsed, you can just come in and ask for it to be placed on the docket.
But
And
we have to wait the 180 days,
mhm,
even though he says that they're giving him 2 for 1, but
mhm. All righty. Okay,
okay.
all right.
Well, then I'll come back and talk to them when 180 days.
Yes.
And then we'll decide what to do.
Yes.
Okay,
All right. Thank you.
Thank you, Rob.
counsel.
thank you.
Thank you. All right, Christopher Ray Martinez. All right, have you had a chance to speak with the state about the assault?
I did briefly, Judge, they do not have any reports. It is too soon. And so they don't have any information that they can share with me just yet.
All right, state, when are you all going to have information on the alleged family violence case? And can you tell me, is that a misdemeanor case or a felony case?
Felony case, Your Honor, and I'm hoping sooner or later, I'm gonna ask my investigator to do so, because it just happened like 5 days ago. There's nothing even uploaded in our system,
Okay,
but I'll see if we can at least pull a report.
all right, thank you. Ms. Ferguson, I need a 30-day reset. All right, so we'll be back on December 4th.
And Judge, he was not present last week because he was in custody. He said that you would consider reinstating his bond. So we asked to reinstate his bond.
All right, let's go on the record. Could I have a prosecutor on this case? Oh, here's my, I just issued a judge's warrant, so I would just recall the judge's warrant. I didn't do anything with his bond.
Okay, Judge.
All right, the court is calling 2025 CR 011500 State versus Christopher Ray Martinez. Can I have parties announced for the record?
Orlando Castanon for defense.
And are you Christopher Martinez? All right, so he was scheduled to appear on court on October 23rd, 2025. He did not appear. Some parties thought that he may have been in custody, but we didn't have any documentation that he was actually in custody. So defense, as an officer of the court, were you able to determine if he was in custody or processing?
I did meet with him the next day, Judge. So yes, he was in custody. It was in process that day.
All right, state, any objection to the court recalling the judge's warrant?
No, Your Honor.
All right, the judge's warrant will be recalled. Is there anything else?
No, Judge.
All right, Ms. Ferguson, if you'll give him a reset form. Okay. And we're off the record. So what he was in custody for was the new.
Yes, Judge.
All right, so here's one thing. Is there a no contact order on the complainant
I
in that
believe
case?
there is.
All right, so if there's not a no contact order under that cause number, I will put I will add a no contact order under this cause number with that complainant. So if y'all can check on that.
I believe it's 3
There,
days.
yeah, there's a no contact order on that new
Okay,
new charge.
all right. All righty, once you sign the reset form, they will take you back. Make sure you're on time for court, 9 a.m. Ray Cordova? All right, so on this case, where are we on discovery?
Judge, I have not received any discovery. The only thing that was uploaded to the discovery were the magistrate warning. So I already conferred with the state.
Yeah, it's uploaded for whatever reason, the systems having problem showing it here, so I just told her to drop off the USB and I'll discover it.
All right, Ms. Ferguson, I need 30-day reset for discovery. All right, once you sign the reset form, you are excused. Thank you. All right, Edward Valdez.
Yes, Judge. We conferred with the state.
All right. Court is calling DC 2023 CR 7270A State versus Edward Valdez. Could I have parties announced for the record?
Amir Memori for Mr. Valdez, Your Honor.
And are you Mr. Valdez? All right. You're requesting a bond for your client, is that correct?
Yes, Your Honor.
And a warrant was issued on September 11th, 2025. The defendant did not appear for court. And that warrant was issued by Judge Angelini.
Yes, Your Honor.
Any questions for your client? Like, why wasn't he here? What type of bond can he make? You'll need to be placed under oath. You raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may state your name for the record.
Edward Valdez,
All right, so what questions do you have?
Why were you not in court on that?
because I didn't know if I had court date or anything. They never approached me to my house or the phone that I gave. I was always working, so I couldn't. If not, I would have gone or called if I wouldn't have made it.
So you've been accepted into the PTD program, correct?
Mhm.
We've signed the agreement, correct?
Yes, sir.
At this point, how much bond can you afford to get out?
To be honest with you, I've been incarcerated since August, so I'm not sure how much.
Wait, you're saying you've been in custody since August? Well, the warrant wasn't issued till September 11th. Why were you in custody?
Because I had the warrants, I had 2 warrants.
No, but what I'm saying, your warrant wasn't issued until September. So you shouldn't have been in custody in August because there was no warrant. What was the warrant for?
It was
It was a misdemeanor MTR. Get a case out of county court, 7 judge.
All right, so he had a case out of County Court 7, and what was that case for?
ABI, family violence judge, and the MTR, there's an MTR on that case.
All right, any other questions?
Not for me, Judge. If you have any questions, please.
All right, state any questions? All right, when's the last time you were employed?
the last time I was employed, it was in BJ's, before I got locked up.
All right. And what was your salary or pay per hour?
$15.
Have you ever had any previous mental health issues?
Oh, man.
Have you ever been diagnosed with any type of mental health issues? Have you ever used any type of drugs in the past?
No.
And this motion to revoke on the family violence case, the misdemeanor, when was that?
Judge, that was, I believe we resolved that on October the 9th, Judge.
And who is the complainant?
That was the MTR, Judge, just to let you know.
Does he have a no contact order with the complainant? Who is the complainant? What's the complainant's name? All right, do you reside by yourself?
Oh, was that me?
Oh, do you live in a home by yourself or there are other people who live with you? I'm sorry?
With my wife,
And who's your wife?
Sylvia Martinez. I've been living with her since that incident. But since I got locked up, I don't know where I stand now,
Okay.
to be honest with you.
And are there any children in the household?
2,
What are their ages?
15 and 12.
All right, state, what are you requesting as a bond amount?
And we're requesting $1,000, Judge.
All right, the court is going to set your bond at $5,000. All right, is there anything else?
No, Judge.
All right, your bond will be set at $5,000. Raymond Diaz?
Mr. Raymond Diaz today.
All right, so where are we on discovery?
I conferred with Ms. Jones this morning. I don't really have too much of it, so what I asked her if I could do is bring her a flash drive, get it all uploaded on there,
Mhm.
and then hopefully on the next setting, we can be ready to talk about offers and that kind of stuff.
All right, is there CPS records?
Here, it's your honor.
And I have a motion for that. I don't know if you want to take it up now.
Yes.
Okay,
Where's the,
And your honor, the state will provide a protective order and give them over to defense with the flash drive.
all right, so if you all will give me that protective order, please. Is there anything else?
no, Your Honor.
All right, Ms. Ferguson, I need a reset date for discovery, 30 days. All right, we'll see you back on December 4th.
Okay.
All right, thank you. Antonio Barrera. And where is he?
He's not present, Judge.
All right, Deputy Laura, if you can make an announcement, please. Court is calling 2025 CR 0070001, State versus Antonio Salinas Barrera Jr. Can I have parties announced?
Defendant for the state of Texas.
Bridget Garza for defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:24 a.m. The defendant has not answered the docket. Defense, have you had any contact with your client?
No, I have not, Judge.
Deputy Laura, did you make an announcement?
Yes, when I did, it's not out there.
All right, state your request.
Forfeit the bond issue, but just more.
All right. The court will issue a bond forfeiture, remand your client without bond. If your client makes an appearance, the court will reconsider.
Okay, thank you,
Thank you.
Judge.
David Bearfield. All right, so court is at 9 a.m. So you need to make sure that you're on time. You understand? All right. State. So I previously represented his uncle. So does anybody have a problem with me presiding over this case? If you do, let me know.
I'll talk it over with my client and see what my client decides.
All right, so Ms. Ferguson, recall this back in 2 weeks. All right, we'll be back on November 10th. At that time, just let me know. What I can tell you, I'll be fair. You know, when I would tell you when I represented Christopher, I would always try to give him words of wisdom to put him on the right path. And sometimes life just keeps beating you down, you know? All right, so we're going to come back on November 10th at that time. Just let me know. No hard feelings, okay? All right. And thank you so much for dressing appropriately for court. Once you sign the reset form, you'll be excused. All right, thank you.
Set it for a status conference?
You can say status, that's fine. All right, Pearl Gonzalez. Is there an application?
No application, Judge.
Probation, there's no application.
Thank you.
Court is calling 2025 CR 008-155, State versus Pearl Gonzalez. Can I have parties announced for the record?
Rene Munoz on behalf of Ms. Gonzalez.
And are you Miss Pearl Gonzalez?
Yes, ma'am. Yes, Your Honor.
How are you doing today?
Pretty good. How about yourself?
Oh, I can't complain. You know, any day you're alive, to me, there's a day to do good things.
Absolutely.
All right. Counsel, have you received all discovery?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the enhancement of it.
No objection.
Ms. Gonzalez, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with the offense of possession of a controlled substance, penalty group 2, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry into the United States?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed to 123 days in the Bexar County Jail under 1244, and there's to be a $700 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor, state offer states exhibit 1 and all.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully requesting that the court follow the negotiated plea bargain agreement, Judge.
So let me ask you, who is Tashawn Powell to you? That was the person you were having the disagreement with?
Yes, that's my girlfriend.
All right. So your priors are a lot of drug cases. Those are your priors. So how are you going to get help for this addiction you have?
I just recently went to the Right Step in Houston.
Mhm.
It's a drug rehab,
Mhm.
and they put me on Suboxone. So I'm currently on a program.
And are you going to continue with that?
Yes, ma'am.
Because you know, if you don't, it's not going to end well for you, right?
Yes, and I'm on it, and the jail too, and there's take me out.
All right,
No.
and has that been helping you?
Yes, ma'am.
All right.
Your Honor, it's my understanding she's gotten help for that issue. I know that this case related is the THC vape pen sort of marijuana. She was not aware that those are still illegal within the state of Texas, but now she does know. So regarding her methamphetamine, heroin past usage, she has gotten treatment for that. And I have advised her fully that even having the THC vape pens could land her getting rearrested or potentially subject to rearrest. And she does understand that now. So she has a better handle on it.
Okay. And do you have a place to stay? And is that place in Bexar County or is it somewhere else?
No, I'm currently working on that. I have to finish the reentry program.
Okay. And do you have any children?
No, not in my custody.
Okay. Any grandchildren?
No.
Okay. All right, this is what the court is going to do. The court will follow your agreement. The court will sentence you to 123 days in the Bexar County Jail under 1244. There's a $700 fine, time and money to run concurrent, and the court will give you credit for any time served.
Your Honor, she has 123 days. With the permission of the court, can her judgment be satisfied?
All right, and when you say 123 days, is that 123 calendar days?
Calendar, day for day, yes, Your Honor, in relation to this case as per the Odyssey system.
All right, then the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When you are released from custody, if you don't know who to call for housing, if you don't know who to call to continue to receive your medication, you can come back here. If I'm still here, I'll pick up the phone and call somebody, okay, for you.
Thank you, Your Honor.
All right, and why the tattoos? What's going on?
So music.
Oh, okay. So you're interested in music?
Yes, ma'am.
Okay, awesome. Well, good luck.
Thank you.
And no more facial tattoos, though. You can put them somewhere else. Your face is too beautiful to be covered up, okay?
I agree.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. All right, Oscar Lopez. Probation, this is an application. Court is calling 2025 CR 006774 State versus Oscar Lopez. Could I have parties announce?
Jeannie Cupid for the defendant.
And are you Mr. Lopez? Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I did.
All right, so I'm gonna need you to speak up a little bit so the
I
court.
did,
will-
yes, ma'am.
Did you review the true bill of indictment with your attorney?
I did, yes, ma'am.
Did you understand it?
I did, yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
About the lesser included offense of assault by.
Any objections?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, yes, ma'am.
State is proceeding on the last lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
I am very,
Did you understand if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States?
yes, I understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. They're requesting a $1,500 fine and recommending the deferred adjudication. Did you understand that to be the plea?
Did.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 18 months. There be a TAP evaluation, 100 hours of community service restitution, and the APSC course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I did.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Do you plead guilty, not guilty, or no contest?
She's stressing the no contest part.
We did go over it, Judge.
I know.
I think he's a little
That's
nervous.
okay. So how do you plead? State any evidence.
Yes, Your Honor, state offer states exhibit 1 and all of that.
Any objection?
None.
State any contact with the complainant?
Yes, Judge, we made contact.
All right, thank you. Did you review the consent and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Anything you wish to say on behalf of your client?
No, Your Honor, we would just ask that the court accept the plea agreement that we have struck with the state.
All right, so you understand you're not supposed to have contact with this person, right? So you let other things overrule your mind to go over there.
It was a big mistake, Your Honor. I learned from this, big lessons learned from this. I know that.
Yeah. And then honestly, if you would have just listened to the police, got out of your vehicle, explained things, who knows? Maybe you still would have got arrested because according to this, you're not supposed to have contact with that person, but you wouldn't be in felony court. So are you employed?
I am, yes, ma'am.
What do you do?
Oil and gas services,
What does that mean?
oil and gas services.
No, I mean, I know what oil and gas services in, but what do you do?
So I've got an oil and gas service company. I started in August of 2013. Main office in the same markets. Most of my businesses in West Texas, Oklahoma, and South Texas.
All right, so do you travel for that business?
Yes, ma'am. From Tuesday to Friday, I'm gone.
Okay. And do you have any children?
I do, yes, ma'am. She goes to school at SMU.
What are their ages?
She's 19.
Okay. And that's your only child?
Yes, ma'am.
Okay. All right. Probation, are you ready? All right, there's to be regular reporting by Zoom or in person. Regular random UAs. How do you want me to place? He says he has to travel for work to Oklahoma and throughout Texas.
Colorado as well.
And Colorado for his employment. Do you want me to just say he's allowed to travel for work? All right. So if you're traveling, you know your days are when?
Tuesday through Friday.
Tuesday through Friday. You need to let them know 24 hours in advance that you have to travel.
Where I'm going to be.
Yes. All right. So defendant is allowed to travel for work. And if your work takes you outside of Bexar County, you're to give probation. Is 24-hour notice enough time? 24 hours notice. There's to be no contact with there's to be proof of employment within 30 days, no employment as a home health care provider or with minors. Field visits one time per month for 2 months. 1 year deferred adjudication. 100 hours of community service restitution. Once he completes the APSE course, the community service hours will be deemed satisfied. Probation, is there anything else? Okay. Oh, and I'm sorry, one final thing. There's a $1,500 fine and that will be probated. If you successfully complete this probation, you will not have to pay the $1,500. If you do not, you're looking at potentially a $4,000 fine. Do you understand?
Yeah.
All right, is there anything else you need from the court to be successful?
Amen.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do.
All right, we can go off the record in this court. To be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to court. All right, and with regards to the regular random UA, since you travel, probation, he can do the regular random UA or the patch. Patch costs more, but with the patch, probation will place it on, and probation is the only people who are allowed to take it off. But I believe it's $300. All right, good luck to you. Once you go over conditions with probation, you're excused.
Thank you, Judge.
You're welcome. Michelle Battles. So, did you receive an offer?
Yes,
Okay,
and we've gone over all the discoverages. We just need to work a little bit on the offer.
all right. Ms. Ferguson, I need a plea deadline date set. Please give it to me in 3 weeks.
I do have a vacation letter from the Thanksgiving stuff.
Oh, no, this will not be set during Thanksgiving. November 17th. All right, we'll be back on November 17th. All right, so at that time, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement with the state by that date, your next court date will be a jury trial date, and it will probably be in the new year. Okay, thank you for dressing appropriately for court. Jesse Martinez. So do you want him here this afternoon?
No, Judge, I mean, the state,
It's gonna need to get some more evidence, so we're gonna need a reset.
So what is outstanding?
We're missing, oh, go ahead, no, go ahead, go ahead.
CPS records, medical records. It does look from our work product that all of that has been requested. What is not been requested is the CPS records.
Okay. All right, Ms. Ferguson, if you can recall this for discovery in December, please.
Fine, Judge.
All right, we're gonna come back on December 15th. And Deputy Laura, if you can let the jail know that he's gonna be need to be brought over on December 15th.
Yes, Judge.
All right, thank you.
Thank you, Judge.
You're welcome. All right, J. McCormick Johnson Timothy. All right, he also has a motion to revoke.
Yes, Your Honor.
This one's second. Excuse me, I need the motion to revoke on Johnson. Are y'all ready to proceed on the motion to revoke?
Yes, Your Honor. We're going open to the court.
All right, have you all done a trial court certification?
Oh, I did not do that.
All right, if you'll do that, please. Court is calling 2024 CR 3084, State versus Timothy J. McCormick Johnson. Can I have parties announced?
Jorge Canales for defense.
And are you Mr. McCormick Johnson?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Oh, yes, ma'am.
Are you the same Timothy J. McCormick Johnson who was placed on community supervision in 2024 CR 3084 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on April 4th, 2024 for a term of 10 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the 9th day of July 2025. And fair counter practices the defendants Timothy J. McCormick Johnson committed the offense of evading arrest or detention with previous conviction in violation of condition number 1.
How do you plead to that? True or not true?
Be true.
You may be out of order.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 10 years in the prison
Yes, ma'am.
and up to a $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
All right, is there a proposed agreement?
Okay. The motion removed the defendant's community supervision and reform his judgment and sentence him to 7 years ago.
All right, defense, what are you requesting?
Your Honor, we'd ask the court to consider continuing Mr. Johnson in this case. This is his first MTR. I know it says second. The first one that he was allegedly breaking was, I believe the court heard this argument before. He was in TDC. He was sent to TDC when he was supposed to be reporting to probation, so he could not report. So in effect, it's his first MTR. He was put on ISF. He placed him on ISF. And
But no, he had I mean, if I'm wrong, I'm trying to figure out, because he had a previous motion to revoke on December 4th, 2024, and it was for a violation of condition number 1. I don't recall what that condition number 1 was, but the court denied the motion, altered and amended his conditions to include state ISF.
that's correct.
So this is his second motion to revoke.
And my first, the first time, they tried to give me the violation.
Oh, you want to raise your right hand if you wish to
Yes,
speak?
ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Timothy Johnson, J. McCormick Johnson.
All right. Yes, what would you like to say?
The day that I signed on probation, it was I brought it to the attention that
I was on parole too, and the day that I signed on probation, I got violated and revoked from probation, so I got sent back to TUC. So therefore, I wasn't able to report for probation.
No, here's the thing. I'm not even focusing on the failure to report because the state has waived that. But your previous, it's been brought to the court's attention. His previous motion to revoke from December, that was a violation of condition number 1, is for evading arrest. And so now we're back here.
Oh, that's from my first month.
Mm-hmm. And on that one, when you played true to that, what the court did was the court denied the motion to revoke, and the court altered and amended your conditions. And now you're back here for another evading.
I didn't even know I had the first evading arrest. I
mean, you played true to it.
I did.
Mm-hmm. And that was in October.
I don't remember that, Judge. So I mean, I apologize. I really don't.
No. I mean, so, and that happened, that evading was alleged, well, I shouldn't say alleged anymore because you played true to it, but that was committed on or about September 27, 2024. So you had that evading case. And then now we're back here for another evading case.
Yeah, the first time I remember this one, I remember and it was a bad judgment call my day. Even officer said that I should have just stopped. I probably got a ticket, but I assumed that a warrant because I missed a house visit. You know what I'm saying? And I missed a house visit probably because of working that. You know what I'm saying? And like, I ain't gonna lie, I'm nervous right now. Like I may not say the right things, and I ain't like I told him I need his help. I'm asking you for your help. You know what I'm saying?
See, here's the thing. I don't know if probation is appropriate for you, and let me just tell you why. Because it appears that you have learned nothing. And let me tell you the reason why I say that. Because you were previously here before for a violation of condition 1, which was evading the police, right? And then you were continued. And now you're not even thinking, you're still evading the police.
No, I'm not evading the police. Actually, I am thinking I got a job, I got bills out there in my name. I'm doing good. I got a good probation officer. I just haven't had time to really work with him, man. You know what I'm saying?
Now the problem is you picked up a new offense, and this is the second
No, I
time.
did. No, I did. The first time I don't remember, so that I apologize. Like, I
Mhm.
mean, there ain't no excuse. That's why I admitted to. There ain't no excuse. I made a bad decision. I'm not on. I'm on. Like I went to ISF because I'm on my meds. I got meds. I was on my meds in the world. But I'm doing good. Like I'm sober. Like I ain't got no drug problems, and I'm doing good, Judge. I got a job. I got electricity and water bill in my name. I got a new residence I'm staying at. I'm not a haven hope for hope no more. I'm actually doing good and got good things going for myself. I just made a bad judgment call on that day. I was probably high that day. I'm not gonna lie. You know what I'm saying?
Yeah.
I'm sitting there, I asked the judge for help, and you offered me 2 years last time, or to go with agreement on the stay in probation. 2 years would have been a blessing to anyone to take. But I
Mhm.
chose the probation because it's challenge for myself, and I believe I could do it.
But see, here's the thing, you chose the probation, but you're still doing the same thing. That's a
I'm not doing the
problem.
same thing. I just made a bad call and made a bad decision on the same day, and I'm not trying to debate with you. Cause y'all understand like stuff that I know, and I can only learn from y'all and others that are in a better position than I am out there in the world. You know what I'm saying? I got a good support system out there. I got my cousin, my boss. I'm in a new relationship. I got things I can lose now. And not just that, my own life is in your hands.
Mhm.
You know what I'm saying? And I understand that. I know I made it. No, I made it. No, I made a mistake.
Just 1 second.
No.
All right. So any questions, defense or state?
No, Your Honor.
Well, here's the thing, we don't shout in court, right?
Right.
You gotta be respectful to your attorney and respectful to each other. All right. So, states you're recommending revocation?
Yes, sir. Based on the true and what's reflected in the court's finding.
All right. Any objections to the court reviewing the court summary?
No, Your Honor.
All right. So with regards to the court summary, the probation is recommending ISF, but the court has previously given you ISF. So I'm going to grant the motion. I'm finding violation of condition number 1 true, and the court will revoke. State, what are you asking for time?
And we're asking to reform the judgment and we're
Defense?
We'd ask you to consider 4 years, Judge. This is, Mr. Johnson is very sorry for breaking the conditions again. We'd ask you to consider 4 years.
May I say something?
Yes.
I understand I just left ISF. I wouldn't have no problem going to there or any other program, because it's only gonna help me better myself, man. You know what I'm saying? There's not a lot of programs. It's an easy way out for me to go to, if I get in time. And then it's not just that, like probably, like I said, I lose my job, my bills, it affects my cousin, because the bills are in his residence, they're in my name, so, and I'm taking care of them. So I wouldn't have no problem going to another program, DDRS, SATF, or ISF, again, because I know that they got cognitive and also got a substance abuse side. And I went to the substance abuse side the first time. I didn't go to the cognitive side the second time. So I don't know if that would still be a possibility for me.
All right, this is what the court is going to do. The court is going to give you credit for any time served in inpatient treatment that was successfully completed, and credit for any time served. There's to be no contact with the following persons. There's to be no residing in households with minors, and the court will sentence you to 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Rogelio. Julian Ariad. Areza. All right. Sometimes I try to add more syllables than are necessary. Counselor, is this an application? All right, probation, there's no application. Court is calling 2025 CR 010624, State versus Julian Araza Jr. Could I have parties announced?
In gallery for the state.
George Schaefer for defendant, Your Honor.
And are you Mr. Araza Jr.? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Araza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we are waiving the punishment enhancement, and then we are moving to proceed on the lesser included offense of possession of controlled substance, PG 1 less than 1 gram.
Any objection?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Right, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days, 2 years in the state jail facility, and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Aranza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I have.
Did you understand if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 77 days in the Bexar County Jail under 1244 and an $800 fine, and there are no applications. Did you understand that to be the
Yes,
plea?
ma'am, correct.
Defense?
It is, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
To the lesser included offense, how do you plead?
No contest.
State any evidence?
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
There are a couple of things I'd like to say, Judge.
Yeah.
While he was out, he has completed the following 2 programs, in addition to which he has become baptized. He has been tested weekly. He's been clean. We ask the court to follow the plea agreement in this case, Your Honor.
All right, and does he still have contact with that apartment complex?
No, ma'am.
All right. All right. The court will follow your agreement, sentence you to 77 days in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrent. There's to be no contact with. Is this a judgment satisfied?
It is, Your Honor.
All right. The court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am, I did.
Did you understand it and sign it in?
Yes, ma'am.
By signing up, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, we can go off the record. So here's the thing. You've done great things. You have to keep up the work. Don't backslide, because it's easy.
Yes, ma'am.
And if there are any friends who are telling you, oh, you don't have to do that today, you got to let it go.
I change people, places, and things.
Oh, and you know what I tell people? It's hard to change people, places, or things. But
Can I say something?
yes.
I'm gonna help out the unfortunate as well too, where he used to be Emerson's bail bonds on South Zamora and Popular. Mondays and Thursdays, that's where I put my time at, feeding the unfortunate, the homeless.
That is
At the impact center, so, I mean, that Shad ministry's been good to me since I got out.
Oh, I'm aware of them.
Yes.
Yeah, the pastor is
Yes,
great.
Robles, yes, so he's real good. I do got a retreat coming up on the 13th that I will be attending.
Oh, you know what? Those retreats are always so great. So here's my question, because there's a relative, we always tease them. Were you baptized in a pool?
I was baptized in Corpus. We
In a
had to
pool?
flood the street in the ocean.
Oh, see, that is what I'm talking about. So we have a relative who was baptized in a pool in the church, and we would always tease them. No, you don't know if you're really saved unless you're in a body of water and nothing bites you. But congratulations. All right, have a great rest of your day, okay?
Bless you, thank you.
Thank you, counsel.
Thank you, Judge.
Henry Medina Rodriguez.
Good morning, Judge.
All right. All righty. All right, status update.
So when we were back here in October 13th, Judge, he had not been screened for mental health court. I did reach out to the coordinator. They started the process of screening him, but unfortunately he does not live in Bexar County, so he cannot get into mental health.
Okay.
So at this point, I would like to speak to the state about the offer. It's Austin Stout.
Okay.
Someone in PIC reached out to him. I don't know if he's coming down, but I can still reach out to him after today. And then can we go off the record on something?
All right, Ms. Ferguson,
Yes, ma'am.
on this case, I need a 30-day reset.
December 12th.
Alright.
December 4th, Judge, I'm sorry.
We're gonna be back on December 4th. All motions need to be filed before then. And you need to have received an offer from the state. Have they tendered an offer?
They have, Judge.
All right. So what we will do is I'll set that for a plea deadline date, but we'll see. Of course, if you have not received an answer in regards to your motion, then that'll be pushed.
Yes, Your Honor.
Okay.
Thank you so much.
You're welcome. Once you sign the reset form, you are excused. Thank you for addressing appropriately for court.
Thank you, Judge.
You're welcome. Jorge Morales.
Judge, good morning.
Good morning.
Through a series of events, Mr. Morales has been in and out of the courtroom trying to put money in his car.
Mhm.
We are going to take a plea.
Okay.
They're going to do the paperwork. I have to be in the 175th to finish up something that I've got down
Well,
there.
he can come back at 1:30.
I cannot be back this afternoon. I have a doctor's appointment. Could we do it tomorrow morning?
All right, Ms. Ferguson. Mr. Morales, we're gonna recall you tomorrow. You need to make sure you're on time. Court is at 9, okay? Once
will
you sign the
prepare.
reset form, you're excused.
Thank you, Judge.
You're welcome. Court is calling 2025 CR 011666 and 2025 CR 011670. State versus Michael Joseph Gomez. Can I have parties announced for the record?
Megan Galloway.
Yeah, Ron Ross, attorney.
All right, this hearing was scheduled at 9 a.m. It is now 11:40 a.m. Defense, have you had any contact with your client?
I have not, Judge.
Deputy, did you make an announcement?
Yes.
All right. State,
Requesting a bond forfeiture.
all right, let me, just one moment, let me see if he's on a PR bond or not. All right, in each cause number, the court is going to issue a judge's warrant. The court will remand your client without bond. If your client makes an appearance, the court will reconsider.
All right,
All right, thank you.
thank you, Judge.
Enrique Lopez. All right, what is with this case?
Your Honor, I'm just asking for a brief reset. We have all the discovery. I just haven't had time to look through it all yet. So I just need some time to review the discovery.
All right, Ms. Ferguson, recall this in 3 weeks for disposition, please.
Thank you, November 13th.
All right, we'll see you back on November 13th.
Would we be able to do that the following week, Your Honor? I'm scheduled to be out of town that day.
All right, we can recall it on November 6th.
November 6th?
Mhm.
Okay.
All right, Nora, put it down for November 6th. All right, we'll see you back on November 6th.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Hello, so where are we on this case?
Judge, I filed a motion for continuance. I have, luckily, one of my cases that was set for trial, in Comal County was reset, this morning, even though I announced it. Then I have another case in the 437 set for trial this morning. And, I'm asking that on top of it, I have an expert that needs to come to the district attorney's office to review the files, and he hasn't been able to. He was just recently appointed a couple of weeks ago, I think, and I need to have him review the files with the district attorney, and I need the continuance.
All right, so the court will see y'all here tomorrow for jury trial because this has been going on for a while with plea deadline dates. Plea deadline dates have been extended. And then we had a final plea deadline date. Then people wanted a jury trial. So Deputy Laura, he's to be brought tomorrow and dressed for trial.
Yes, Judge.
All right, thank you. James Ross. All right, we're set for contested hearing. State, are you ready?
Yes, sir.
Okay.
We're not ready, Judge, if that's appropriate to say at this time.
I mean, yes, but I mean, it's set for a contested, so it's going.
Well, I wanted to bring something to the court's attention, if I
Okay.
may. Mr. Ross and I, as the court was probably privy to, are not on the same page, in very substantial ways. Such that I don't think that it would be productive or civil for me to continue representing him.
I mean, I understand what you're saying, counsel, but we were here in August and it was set for a contested hearing for October 9th. And then it was reset for today for a contested hearing. So the state has their witnesses. We're going to proceed.
I guess I'll say this, if I may. We're not getting along. I think it's very much affecting my wanting to and desire to represent him, because I don't want to be cowered over and yelled at.
So here's the thing, you can't be yelling at people. That's it. So your attorney is here to represent you. You have a motion to revoke. You're on probation for possession of a controlled substance, penalty group 1, 4 to 200 grams. Your underlying is 8 years. So that means if the court were to find the allegations within the motion true, then you're looking at 8 years. Now, if you want to shout at your attorney, I don't know why you would do that. I don't know why you would raise your voice to your attorney. That's on you. But I can tell you what's in this motion to revoke. Just one moment. So we're going to proceed. Court is calling 2024 CR 0087333, State versus James Ross Jr. Can I have parties announced for the record?
Needham McCray on behalf of Mr. Ross is to my right.
And are you James Ross Jr.? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same James Ross Jr. who was placed on community supervision in 2024 CR 0087333 for the offense of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams on February 13th, 2025 for a term of 9 years? Is that you?
Yes, Your Honor.
State?
We should have condition number 2 on or about the first day of May 2025 in Bexar County, Texas. The defendant, James Ross Jr., did then and there illegally use amphetamines and violence.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 2 on or about the first day of May 2025 in Bexar County, Texas. The defendant, James Ross Jr., did then and there illegal use of cocaine and violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bexar County, Texas. The defendant, James Ross Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2025 in violation of condition number 4.
How do you plead to that?
Not true, Your Honor. To one of them.
All right,
I
not
did not.
true to which one?
I did not.
Waive violation of condition number 1, 4, and 14, which is
Any objections to the waivers?
None.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion,
well, you know what,
and sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2?
that the court's only option.
No, I'm telling you what you're looking at. What you're looking at for any violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with Your attorney is not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine. Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
Yes.
Court will find 2 and 2 true. Is there a proposed agreement?
State is requesting not to grant the state's motion, and for those two defendants can use supervision and sentence them to the 8 years in the prison based on the plea of truth here today, and then based on the underlying facts in the case that he's placed on probation. The state made punishment enhancements through that and recommended community supervision was done by a prior APA. And based on that amount that was he's in possession of at the time of the offense and continued use and possession of all substances.
All right, defense, what are you requesting?
We're asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all make mistakes. We all have relapses. He was on probation for a drug offense. And he made note to me. He said, the judge told me when I pled that if I ever have problems, to contact the probation department, to let them know, to work with them. And that reflects well on me if I ever came back.
Did he do that? Probation?
There would have to have a moment.
And I'm not considering it because I know the number 1 was waived. However, inpatient treatment is not going to be available for him until that case is, whatever is done with that case.
I don't have any notes in the campaign that there were specific drug dating. I don't have any looking that in the notes that, that was something that was that he was having issues with that. There were several bill visits. And I don't see anything there either.
If I may, Judge.
Let me just finish and then I will hear you, counsel.
But I don't have any of that information. We only obtained one UA, and that one UA was the positive one listed. Then been on since February. And then the big one happened. So yeah, I don't have any of that, Judge. The officer is on standby if this was going to be contested. If you would like to speak with her, I can get her on the line, Judge.
All right. Any objections to that witness being by Zoom at 1:30?
None.
All right. So Ms. Abrams, if you'll let her know, we'll be back at 1:30, and if she can look through her files between now and then. All right, we'll see y'all back at 1:30.
Thank you, Judge.
Deputy Laura, on this one, we're gonna do the plea, but if you could just put a hold on him to come
Yes.
back. No, I mean, this person.
Okay, you want me to put them on hold already?
Yeah,
Interpreter's already here.
no, because she's gonna need the interpreter, and I like to give people their lunch breaks. All right, the court is calling 2025 CR 010576 State versus Raul Rincon. If I could have parties announced for the record.
Pertaining to the state of Texas.
And are you Mr. Rincon?
Yes.
All right, we have an interpreter. Hello. Could you raise your right hand for me, please? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Mr. Rincon, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes,
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do, Your Honor.
Mr. Rancone, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes,
Counsel, have you received all discovery and did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rincon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
we do, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Rincon, did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes,
You're charged with assault, family, household impeding breath or circulation. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
If the court grants your application for deferred adjudication, if for any reason your deferred adjudication is revoked, the court can find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
yes,
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is competent to proceed, Your Honor.
Mr. Rincon, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No. No,
Anyone promised you anything other than the plea?
no, no.
Are you satisfied with the way you've been represented?
Yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-enter into the States. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They will take in consideration 2025 CC 012646 and 2025 CC 012647. There's an affirmative finding of family violence. There's to be no. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
yes,
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
yes,
Did you understand that to be your plea bargain agreement?
yes,
Defense?
yes, Your Honor.
State?
Yes, that's a true.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
no, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be 100 hours of community service restitution, the BIPP course, a TAP evaluation, follow TAP recommendations, and parenting class. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence?
No objection, Your Honor.
State, have you had a chance to speak with the complainant? All right, thank you. Mr. Rincon, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, the state will be presenting evidence through the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client just wishes to just go move on, and he accepted responsibility for his actions, and he just asked the court to follow the recommendation, and he knows he can do his probation.
All right, why did you do this?
I'm gonna do my probation the way it's supposed to.
No, my question is, why did you commit this offense? I mean, what don't you understand? If somebody is cheating on you, you have two choices. Either you accept it or either you leave. But for you to do what you did, and then you have a 6-year-old involved in this nonsense with you, why are you doing that?
Well, I just wanted to take the phone away from her.
Yeah, and she didn't want to give it to you.
No.
I don't know why people think you are not her father. You are supposed to be in an adult relationship. What I can tell you is that relationship is over. You're not to contact her or call her. There's no need for you to worry about her cheating on you because you're not to have any contact with her. And she can date whomever she want to date. But the one person she won't be dating is you. You understand?
Yes.
Do you have any children?
Yes, I do.
How many?
I have two. I have 2 children, but in Mexico, no, not here.
And have you had employment since you've been here?
Yes.
All right, the court is going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Karina Gomez or Mia Gomez. Proof of employment within 45 days, no employment as a home healthcare provider or with minors. There's to be no residing with minors. Well, no residing in a household with minors. There's a $1,500 fine that will be probated. Regular reporting by Zoom or in person. Regular random UAs. Take in consideration 2025 CC 012646 and 2025 CC 012647. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. The BIPP course. Field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else that you need to be successful?
No, that's fine.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. We can go off the record. How old are you?
37.
All right. Don't get into another relationship until you get an orchid. And that orchid, when you get it, it's going to have blooms on it. Wait till those blooms fall off. And if you can get that orchid to rebloom, then you may be ready for a relationship because orchids require patience. All right. Good luck to you.
Thank you.
You're welcome. All right, so the record can be clear. Both parties have no objection to Officer Dixon appearing by Zoom,
That's correct.
and it's to get clarification or testimony in regards to whether or not Mr. Ross reached out to probation with any problems with his sobriety, and also to ask questions for whatever either side wishes to question the witness about. So there's no objections to the witness appearing by Zoom, is that correct?
No.
All right, Officer Dixon,
Yes, ma'am.
could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. All right, if you'll state your name for the record.
Tamia Dixon.
Miss Dixon, how are you currently employed?
I'm employed as an adult probation officer.
Okay. And in your duties as an adult probation officer, were you assigned to supervise James Ross Jr. as part of your case?
Yes.
Okay. And while supervising him, are you aware of who read him his terms of probation?
Yes, me.
Okay. And is one of the terms of probation that he is to report to you?
Yes, ma'am.
Okay. When is the last time, do you know how long or how frequently was the defendant supposed to report to you?
Once a month.
Okay. When is the last time that the defendant reported to you?
The last office visit was April 25th,
And what year was that?
2025.
Okay. And after that, had you spoken with the defendant, like on the phone or by any other means?
So his last visit was April 25th. And after that, I did not hear from him until June 9th, 2025.
Okay. And regarding the conversation on June 9th, 2025, without getting into the specifics of it, were you made aware of a warrant for his arrest?
Yes.
Okay. And what did you instruct him to do when you spoke with him on June 9th, 2025?
Once I spoke with the detective and he verified that the warrant was active, I instructed him to turn himself in and handle the warrant to clear it.
Okay. And to your knowledge, was that done? Well, actually, let me rephrase the question. Did you speak with the defendant again on June 12th, 2025?
June 12th. No, I do not have record of that conversation, no.
Do you recall ever speaking with him again after June 9th, 2025?
After June 9th, I talked to the detective, I talked to him. I didn't document it, so no.
Okay. Now, regarding the reporting that was supposed to be monthly, was that to be in person?
Yes, we were to report, he was to meet here in this office once a month on a date that I gave him.
Okay. And so any communication that you had with him via telephone, that would not satisfy the requirement for him to report to you in person. Is that correct?
That's correct. Unless I told him something like, oh, this can count, or we could reschedule or anything of that nature, but that was not done.
Okay. Now regarding, were you made aware of any positive drug test regarding this defendant?
On May 1st, 2025, he did result positive for amphetamines and cocaine.
Okay. And so since you said the last time that you spoke with him in person was April 25th of 2025, between that date and the date that he tested positive and then the date that you spoke with him on June 9th of 2025, did the defendant ever report to you having a substance abuse issue, which would require him to go inpatient or anything like that?
No,
Okay. Did he ever ask for any help specifically regarding substance abuse?
no,
Okay. And as far as the conditions that were in place for him, were you ever provided with any proof of completion of a parenting course?
let me check. I'm checking right now. No, I was not given a certificate of completion.
Okay. And then regarding any community service hours, did the defendant provide any proof that he completed any of the 200 hours that were assessed?
No, no completion was submitted.
Okay. We passed the witness, Your Honor.
Defense?
I just want to get some clarification. You said there was a positive drug test on May 1st,
It was May 1st, yes.
and where does that drug test take place at?
He goes to either recovery downtown or he can come here on Mondays and Thursdays here at Bandera location.
Could you please tell us where that May 1st test was taken at?
Let me check and see. It tells me RMS, but I'm unaware if it's Bandera location or downtown. I just know that it's RMS.
And what does RMS stand for?
Recovery Medical Services or something like that. Yeah.
Is that the test provider?
Yes, that is. That's where they go and submit their drug test.
Okay, and so what you're saying is that your notes are inconclusive as to whether or not he came into your office in the month of May.
In the month of May, yes. I am unaware if he came here or downtown.
Okay, and when he comes to your office, I imagine he doesn't direct himself as to what to do when he arrives.
When he comes for a drug test, he's not to check in with me. He's only to check in with the drug test providers when they're here. So regardless, I wouldn't have known if he was here or not because he does not check in with me when doing drug tests.
Okay, were you available that day when he showed up?
I'm not sure if I was available or not. I wasn't, he didn't ask for me or anything. I probably was in a meeting.
Okay, fair enough. Now, my next question is, did you receive a call from him on June 1st?
June 1st. Let me check. No.
Are you aware of the offense date of the alleged, I think it's new number 1 in the MTR allegations?
Let me check the MTR. I have it pulled up. The alleged date is June 1st, 2025.
Do you recall speaking to James Ross about that new number 1, the day that it happened? Did he call you or speak to someone at your office?
No, not on June 1st.
So my question to you is, do you document any and all communication with the client or just those that you deem to be relevant?
All of them.
And it's your testimony that you did not speak with James Ross regarding his new number 1 allegation?
Not on June 1st.
When did you do that? When did you have that conversation, I should say?
On the 6th, the same day that I talked to the attorney about the case. It would be on the 6th. Because that's the same day I talked to the detective,
So then you talked to James Ross on the 6th, and then you also talked to him again on the 9th, is what you testified to previously.
So I talked to the detective. I talked to him and the detective on the same day, not the 6th, on the 9th.
Thank you for clarifying. And what you're saying is between June 1st and June 9th, you had no contact with James Ross?
No.
Did James Ross send you any documentation from his most recent number 1 allegation that the state is alleged in the MTR?
Let me check my email. I'm checking my email as of now. No, the last email I received from James Ross was April 2nd, 2022.
Did he ever
I
send?
mean, I'm sorry, 2025.
No worries. So it's your testimony that he never sent you a Cash App receipt dealing with the new allegations that he was facing?
Judge, I'm gonna object as to outside of the scope. We've waived that, and she's not like a fact witness or anything, so.
Well, in response, Judge, we're here trying to establish whether or not he stayed in contact with probation, and that's the only line of questioning I'm trying to pursue.
All right, the objection will be overruled.
Again, did you receive a receipt from James Ross regarding his new allegation that was, I believe, a Cash App receipt?
Okay, it shows here. Actually, I have an email. After the second, I received the email on 6/17/2025. Payment, please call the probation. It was a payment from Bear County. He submitted a payment towards his financial obligation on the 16th of 2025, and that was forwarded to me.
And what month was that again?
That was June 16th, 2025, and it was a payment of $34 towards his financial obligation.
Okay. So you spoke with him on the 9th, and then he made a payment on his probation fees and costs on the 16th?
On the 16th, yes.
And when was, and you said that, and just to be clear, you said that the positive urine screen was May 1st.
May 1st, yes.
Thank you. No further questions.
Nothing further, Judge.
All right, is this witness excused?
Yes, Your Honor.
Subject to recall.
All right, does anyone have another witness?
Judge.
The defense would like to call Mr. Ross.
All right, could you rate, you're still under oath. All right, you may proceed.
Just one more. Mr. Ross, on the date of the new alleged number 1 against you, did you call the probation department or Miss Dixon that day that it happened?
I did.
Who was with you when you made that call?
Twanya Monday.
Who was Twanya Monday to you?
All right, first of all, for the record, if you could spell the first name.
TWONYA.
All right.
And what date do you recall speaking to Miss Dixon?
It was the date of the alleged robbery. I believe it to be the 1st.
The 1st of what month?
June.
Is that a 2025?
Yes.
When you called her, did you reach her directly or were you rerouted to her when you called a general number? How did that work?
I reached her directly. I called to the office.
Okay. When you spoke with her, did you identify yourself?
I did.
Did you communicate to her about your circumstances and what had just happened to you?
I did. Told her I was worried that I was gonna get in some trouble with this woman who was not trying to pay me for the work I'd done.
Okay. Now, without getting into the facts and circumstances of the case, why did you feel compelled to call Miss Dixon on the date that this incident happened?
Because after me and my girlfriend left, I saw police shooting past us in the opposite direction from which we came. So I felt like she'd called the police.
Okay. And you wanted to, as a result, make sure that you talked to probation and let them know about this alleged incident.
Right, I did.
Now, after June 1st, when is the next time you spoke to Miss Dixon?
When the detective contacted me to come to an interview with him.
And what day was that?
I don't remember the exact date.
Was it the same week as the incident?
I believe it to be, yes.
She's testified, I believe, that it was June 9th. Would you dispute that date?
No, I wouldn't dispute it.
Okay, sounds familiar to you?
It does.
Okay, and as a term and condition of your probation, you know you're not supposed to have police contact, correct?
Right.
And the detective would qualify as police contact. Is that fair to say?
It is.
And as a result, you wouldn't contact the probation to let them know about that contact.
I did.
Now, on June 16th, Ms. Dixon has indicated you sent her an email. Do you recall doing that?
June 16th?
Or whatever day you recall sending an email.
I do. That sounds familiar because I sent the detective the same copy of the receipt from the Cash App transaction. And then I also sent it to my probation officer so someone else would have it besides just a detective.
And again, we're not getting into the facts and circumstances of the case. We're just talking about communication.
Right.
And that email was sent around the 16th of June, 2025?
Yes.
Okay. Now, there was also some mention that you paid a fee. You recall doing that?
I do. I was trying to stay current on my probation fees.
Did you contact anyone at probation before you made the payment or after?
I don't recall,
How did you make the payment? Online or did you go into the office?
online,
Okay.
I believe.
After you made that payment, did you hear from Ms. Dixon at all?
Yes, after she spoke with the detective, next day, after she spoke with the detective, she instructed me that I should go and turn myself in.
Okay, and I'll leave it there. Thank you. No further questions.
All right, any questions?
Yes, sure. All right, Mr. Dixon, so you're here, or Mr. Ross, you're here because you're on probation for possession of a controlled substance, PG 1 or 4 to 200 grams, is that correct?
That's correct.
Okay, and so I want to take you back to May 20th of 2024 when you were placed under arrest for the offense that you're on probation for. Do you recall that day?
No,
Okay, and so that day you were traveling in a motor vehicle, is that correct?
yes, it was not mine.
Okay, but you were in the driver's seat, correct?
Correct.
Okay, and you were with another person on that day that was in the passenger seat, correct?
Correct.
Okay, and so the officer pulled you over for a defective headlight, is that correct?
Allegedly.
Okay, well, you understand that this was stipulated to, correct? When you took the plea, you said it was true and correct. You remember that?
Well, Your Honor, I'm gonna object at
No,
this
it-
point.
Okay, go
For the
ahead.
simple fact that if he pled no contest, the court simply establishes a record, there's a basis to prove the case beyond a reasonable doubt. That doesn't mean he's agreeing necessarily with everything in the report.
Well, Judge, and I can ask him about it because it's part of the stipulations in the court's record. And it's going to whether he's actually a user, as they're claiming, or whether he had other intentions with the Controlled Substances Act.
All right, the objection is overruled.
Okay.
Just really quick, I'm just trying to clarify so we understand. This line of questioning is about whether or not he's a user of drugs versus a seller of drugs. And he's on probation for using.
His estate waived the first count. So if I'm getting to blame my predicate as to what was found on him.
Okay, and he tested positive for drugs while on probation, which is used as well.
All right,
Users can.
the objection is overruled. The court will hear the question and the answer.
Okay. And so you understand that the officer stated that when he approached the vehicle that he smelled an odor of marijuana, right?
Understand that to be so.
Okay. And so when the officers searched your person, in your pocket, you were in possession of a scale, is that correct?
Allegedly.
Okay, if that's in the stipulations, are you now disputing or contesting that?
I don't recall.
Okay,
That day it was lights blinded me in my face. I was snatched out the car and everything happened so fast. I really don't remember.
okay. And then after that, you were in possession of 13 grams of methamphetamine, is that correct?
That's not correct.
Well, I guess let me rephrase it. It was actually 17, but by the time it got to the lab, it was 13, correct?
Well, Your Honor, I'm gonna object to that line of questioning because there's a field test and there's admitted labs through a state certified crime lab. Which one are we going off of? Because there's a reason
Well,
there's a state certified crime lab.
is he gonna answer truthfully or not?
We're trying to figure out what the question is, the 17 grams or 13 grams. We're just going with whatever the
Objection
stipulation.
is overruled.
So how much methamphetamine were you in possession of?
Possession of any,
So then why are you on probation for possession?
because I didn't want to lose my apartment that I just got and I wanted to be free, so I signed for something.
Okay, so help me understand this then. You're here asking the court for help because you have a drug problem. Is that what you're asking the court for?
I wasn't aware that I was asking the court for anything.
So you understand that you were here on a motion to revoke probation. You were present earlier before the lunch break, correct? And you heard the state asking the court to revoke you for 8 years. Is that correct? Okay, and you don't want to go to prison for 8 years. Isn't that true?
That's correct.
Okay, so what are you asking the court to do then?
To understand, like, hoping not to get revoked.
On what basis?
You're charging me with, you're saying that I violated for 2 things only out of the 10 that you put on there. Saying that I was charged with this frivolous crime because I was panicked.
I'm very confused right now. So are you saying that on the date of the offense that you're on probation for, that you had been under the influence of a controlled substance, but you weren't possessing it? Is that what you're saying?
Yes.
Okay. Moving on. So you were smoking marijuana then?
I think we need to, just for clarification, Your Honor, the word possession has a lay meaning and a legal meaning. And I think maybe that clarification is where the question.
No, I mean, you can
Fair enough.
recross, or I should say redirect.
Okay, and so it's your testimony. I mean, are you disputing that Miss Dixon testified that the last time that she saw you, that she personally observed you in her office, was in April of 2025? Are you disputing that?
No.
Okay, so to be fair, you never made contact with Miss Dixon in person after April of 2025. Is that correct?
That's correct.
Okay, but it's your testimony that you had called and made contact with some different people at adult
No,
probation.
that's not my testimony.
Okay, well, explain to me. Go ahead.
I called Miss Dixon and tried to reschedule my appointment for the end of May, June. So I went in May and took a drug test to her office, but I didn't see her. So I made the payment and took the drug test.
Okay, so that's the drug test that came up positive, right? The one that was May 1st. Okay, and so you didn't report to Miss Dixon that day. You reported to the person that administered the urinalysis to you.
I actually did call her that day. And when I called her, I told her that, you know, I'm gonna come take this test. I'm running late. So can I take it on the second half of the day? And I made it right before they left. So I was the very last person in there at like 5 o'clock. So when I showed up, and they allowed me to take the test.
Okay. And then you heard Miss Dixon testify that on June 16th of 2025, you submitted a payment of $34 to probation, correct?
Right.
Okay, and you stated that that's because you wanted to stay current on your fees. Is that correct?
To show the court that I'm actually trying and I'm taking it serious.
Okay. And so $34 was the highest amount of payment that you could make at the time?
Because I wasn't employed.
So then how do you have money to test positive for cocaine and amphetamine?
I have one, excuse me, to test. It was
No,
$11.
to buy
I didn't
controlled
buy.
substances and invest them.
How
How did you?
that I bought them? I just told you that a friend came and smoked with me.
So it's your testimony that your friend came to your home and bought methamphetamine and cocaine. We all smoked it.
I didn't know about there being any cocaine, but I smoked meth then.
You smoked meth.
So it could have been in it. I wasn't aware of it because I didn't snort no cocaine.
Okay, but you didn't financially compensate this person for the narcotics, is that correct?
No.
Okay.
Didn't.
You understand that as a term of your probation, you're not to hang around with people that engage in drug use and have criminal records, correct? Okay.
No, it's not my intention to be that way. I was under the stress of catching a whole aggravated robbery. That's what.
But you didn't reach out to probation and tell them, hey, I'm feeling so stressed. I'm about to use, can you please help me? You didn't do that, right?
I called and let them know I called that I was worried about a case.
Did you specifically tell them that you were so worried that you were going to ingest narcotics is the question?
No, but I went to.
Thank you. And then regarding Tanya Monday, you stated that's your girlfriend?
Yes.
Okay, and she was with you on June 1st of 2025, correct? When you went to the alteration shop, she was with you?
Yeah, she took me. She asked her to bring me back.
Okay. We have to witness, Your Honor.
Just for some clarification. And this is an important question. You're saying on May 1st, when you went in for your drug test, you did speak to Ms. Dixon?
Yes,
Okay. And you're sure of this because you were running late that day and you ended up having to take your drug test later than usual?
right. I was supposed to take the first half of the day because they come and they leave at 1:30 and then they come back second half until 4:30.
And if you miss your appointment or you don't reschedule, that's a violation. You understand that?
I do.
And so you weren't violated that day, were you?
I was not.
So someone had to have allowed you to take it in the second half of the day rather than the first half of the day. Is that fair to say?
Yep, they're only there on Mondays and Thursdays from.
My question is, the day that you came late, you had to have permission to do that. Is that correct?
Yes.
Because otherwise, if you had not taken that test, you would have been violated, correct?
Correct.
Okay, so somebody gave you that permission. Is that correct?
Correct.
And you're saying that somebody is Ms. Dixon?
She told me that I could come in and take it before they leave, but I must make it before they leave.
No further questions.
I don't have anything further, Your Honor.
All right. Are you asking to recall Ms. Dixon? All right. Thank you, Officer Dixon. Court will hear argument.
Judge, so I'm re-urging the court to grant the state's motion, revoke the defendant and sentence him to 8 years in the prison because this is clearly a person that has no intention of being on probation or doing good on probation. Essentially, we've called Ms. Dixon here to just call her a liar and say that she doesn't document correctly and that what he is saying to the court is true, that he did reach out on all these days that are not documented. And then I take issue with the fact that he's not even taking responsibility for the case that he's on probation for. He stipulates that the stips are true and correct, and then he wants to come in here and say, I don't remember, it wasn't that much meth. It wasn't mine when it was found exactly where he was sitting. Like, notwithstanding all of the testimony that's come today, the fact remains the same that probation has not heard from him or Ms. Dixon herself when he's supposed to be reporting monthly. Ms. Dixon has not seen him since April 25th of 2025. And that's an important fact for the court to consider because what is the purpose of defendants reporting to their probation officer? And so their probation officer can offer them assistance. So their probation officer can see, are they under the influence of narcotics? Are they being tempted? Do they need help? And he can't even do something as simple as that. And so, Your Honor, we are asking that you revoke him and sentence him to 8 years.
Your Honor, and the court is privy to its own record and also access to probation. He was never required to report in person. He was reporting by Zoom. And so this idea that him going in person versus not in person, the bigger question is, was he reporting? He has this missed report date in May. Now, I am just speaking, I guess maybe in, I don't want to say realistic, but just maybe everyday ways of doing business, right? You establish a relationship with someone, and as things happen or unfold, you document, or whatever the case may be. I do imagine that there are conversations that happen that are not documented. And that's okay to the extent that it's, I'm running late. Okay. And what I'm trying to draw out is that on this particular day, when he's supposed to test on May 1st, he's testified that I was supposed to be there in the morning. I was running late. I was allowed to come in the afternoon. The court is very well know, if you're running late for a test, that can be used against you. You can be denied a reason to test, and that can be a violation. So someone gave him permission to do that. He's saying my probation officer did that. So if he's having contact with her on May 1st and there's no documentation of that, I get it if it's just simply a call of, I'm running late. And that's fair. Those things happen, but that shouldn't be used against him to say he didn't have contact. I don't know if that amounts to a formal meeting, right? A formal sit down or a formal Zoom call. But I think the idea of what we're trying to portray to the court is that he is trying to stay in compliance with probation. He's showing up for the test, and he did have contact in May.
So here's my question. My understanding is that this witness was being called because he said that I told him if there were any issues to reach out to probation. And so maybe my assumption isn't correct, but I assumed that this witness was going to be called to testify whether or not he reached out to her saying, hey, I have a problem maintaining my sobriety. I thought that's what her testimony was about or is supposed to be about. So that's what I'm looking for from this witness.
just to clarify that, Judge, I think something got lost in the translation there.
Mhm.
What we're communicating to the court, just for clarity, is that when he got in trouble on June 1st, he called his probation officer.
But I mean, if you, and correct me if I'm wrong, but if you are charged with a new offense, according to the conditions of probation, you're supposed to reach out to your probation officer and say, I'm picking up a new case. He has pled true, and what he pled true to was the use of drugs. And then my recollection, if I'm wrong, please correct me. I don't hold it against anybody for correcting me. Sometimes I can be wrong, but he pled true to violations 2 and 2. And then he said, Judge, you told me if I ever needed any help to reach out to probation, and that's what I did. So I'm waiting for this witness to testify about his reaching out to her that, hey, I'm having problems maintaining my sobriety. If I am wrong in what I thought this witness was being called for, somebody please correct me. But that was my understanding.
If I may,
Yes.
Your Honor, I wasn't having any problems until this alleged robbery took place. When this alleged robbery took place, that's when I reached out to my probation officer, because to that point, I hadn't had any problems at all.
But the alleged, and I'm not taking this robbery as true, right? But the positive UA that you've pled true to happened in May. The alleged new case is on or about June 1st, 2025. Is the alleged new case on or about in May as opposed to June?
No, it's June.
No, that drug test is not on the correct day. That drug test was taken before I had the interview with the detective. I wanted to hurry up and get that done because I knew that it was possible that this detective could put a warrant out for my arrest. And I knew that once that I went up there and went to report with my probation officer, that if I got a warrant for my arrest, I'd be arrested. So as soon as this happened, I went up there to take that drug test. So that date, it must be in question, Your Honor.
So you're saying you didn't take a UA on May 1st, 2025?
I don't remember that date specifically. But I do remember running up there to take it because I asked my probation officer, or she instructed me to take the drug test several times, and I kept missing the appointment. And so this one I refused to miss. So I drove up there as fast as I could, got there right as they were closing. And
So you're saying they put the wrong date down. It didn't happen on May 1st.
so
Okay.
Judge, and if I could just address one thing, I specifically asked him the question if he ever reached out to probation regarding sobriety issues and letting them know that he was under so much stress that he was gonna ingest narcotics, and the answer was no.
that is so, Your Honor. When
I think the inference from this is, Judge, I'm being looked at, I'm under stress, so I use some drugs. I reported and took my drug test. That's been documented. I spoke to my probation officer that day. I don't know if that amounts to a meeting or not. And in June, I also made contact, right? And also submitted to a test and made a payment. Those facts can't be disputed.
But here's the thing, for the court, it's not even, of course, you shouldn't be testing positive while you're on probation. But my understanding is that the whole reason for this witness testimony was not whether he reported on this day or that day. It was about whether or not he reached out to his probation officer to say, I'm under stress, I'm having trouble maintaining my sobriety, help me. Because he told me, and if I'm wrong, again, somebody correct me, we can have the court reporter read it back. He said, Judge, you told us we could reach out to probation for help. And I did that. And I haven't heard any evidence that he reached out to probation saying, hey, I need help. I'm about to use, or I'm struggling maintaining my sobriety.
And just to pick up on the court's point, I think the miscommunication comes because he has a different recollection of the timeline for the test. And what I'm trying to draw out is that when he got implicated in this new situation, he did call. That the timeline
Did he call and say, I'm having trouble maintaining my sobriety?
He called and said, I'm being looked at.
No, Did he call and say, I'm having problems maintaining my sobriety?
He didn't handle the stress of that well, and he did use drugs, but he did show up for the test, knowing that he was dirty. He still showed up.
But no, did he? Because I'm trying to figure this out. Because he said that he reached out to probation because I told him if he ever needed any help to reach out for probation. And that's what he told me after he pled true to violations 2 and 2. So my question, and if it's yes or if it's no, it's just something for me to consider. My question is, did he reach out to probation and say, somebody help me? I am having problems maintaining my sobriety. That's what I need to know.
I would say the judge, you're correct that he did not communicate that. I'm just simply saying the reasons for that is I think the timeline was misunderstood. He committed this new offense, which he did communicate. After that, he said he spiraled a little bit and started using drugs, but still showed up for his drug test, even though he knew he was dirty.
But isn't the drug test before the alleged new number one?
There was one before and one after. I think the second was around June 16th or something like that.
No, both of these positive UAs are on or about May 1st.
So those, I don't believe that date to be correct, Your Honor. And you are correct, Your Honor. I did not reach out for the purpose of help with sobriety at that point. When I found myself in trouble and I wanted to make record that this is what's going on, I needed some help. I didn't know who else to call about this situation that I was in. So I called my attorney. I called my probation officer and said, hey, I've been working for this lady. This thing is not seeming right. I feel like I'm about to get in trouble. I want to make record with you. Can you tell me what to do? And she did. That's the help that I called for initially. And I didn't make a call after that for help with the drugs.
And drugs are tough, Judge. They're highly addictive, and once you're on it, it's hard to get off.
I'm serious about my sobriety, Your Honor, and I've been going to AA classes and NA classes the whole time I was on probation, and the whole time since I've been here, I've still been participating in these classes on a weekly basis.
Okay. All right. Is there anything else from either side?
Nothing further.
All right. So the court is going to grant the motion. States you're asking for 8. How much time are you requesting?
It's a drug offense, Judge. We would ask for the minimum so he can get the help that he needs. I know TDC also provides some drug treatment programs. He's been participating in the jail since he's been arrested. And as he indicated, he was going to AA and NA while on probation. So I think he could benefit from some treatment. I believe that, again, a minimum sentence would allow him to get the treatment he needs in jail and come out and get on the right foot.
All right. If you'll go over the trial court certification with him, please.
This is not a plea bargain case.
No, you all just have to fill out. I'll make the decision on. No problem.
This is your appellate rights form. She's going to call you on the record. What your right of appeal is based on this particular hearing. I checked this box. She's saying don't check that box. She's going to check the appropriate box and make a record of the box that she checked.
So what am I signing?
Reserve defendant.
This could be me signing that we're going to prison.
No, this is you signing, saying I understand what my appellate rights are. You make the decision on it. This is saying I know what my appellate rights are.
So we are there. So we are now at a point where Your Honor is on the side on how am I getting in prison?
I believe so.
And if I don't sign this,
You don't have to sign it. Pass it here, please.
Your Honor, I don't want to anger you. I've been.
Oh, no,
so
here's the thing. I'm not angry. I don't get angry.
I mean, not anger, but I want to cooperate with you, Your Honor.
No, you don't have to sign it if you don't want to sign it. What I can tell you, that document tells you whether or not you have a right to appeal. And I'm the person who makes the decision on whether or not you have a right to appeal. And so once you sign that, I will let you know.
He's put his mark on it.
All right, thank you. So this is what the court is going to do. See, this is why you all shouldn't be checking the boxes, because the box checked is the incorrect box to check.
I didn't check that box, Your Honor.
Oh, I checked it. It's different by each county.
No, that's the incorrect box to check. So to attorneys going forth, the trial court certification of defendant's rights to appeal, you don't get to decide whether or not your client has a right to appeal. That's the court. So the court should be checking boxes, and you all sometimes check wrong boxes. All right, this is what the court is going to do. Court is finding violations 2 and 2 true. The court is going to grant the motion to revoke. The court is going to sentence you to 4 years in the prison, give you credit for any time served. The therapeutic community, there's to be no contact with Mark Daniel Lewis. There's a $2,000 fine. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you, Mr. Ross.
Yeah, that's the question.
Sure.
So been sentenced to 4 years CDC,
Yes.
and what about the aggravated robbery charge?
Need an activated trial date.
All right, that's still pending, and just one moment with regards to that. Counsel, have you received discovery in that case?
I would need to check with my investigator and make sure we have it all.
All right, let me just look and see what the cause number is for that. All right, so it's set for December 9th. So we'll see you back on December 9th. On Israel Cortez. Is Israel Cortez in the box?
Yes, yes.
If you can come down briefly, sir. Is he a Spanish speaker? I don't think it doesn't, it's not listed on here as a Spanish speaker. All right, Mr. Cortez. Your attorney is actually in a jury trial, so we're gonna have to reschedule you and we'll recall you for next week, okay? Do you have any questions? All right, so we'll see you back next week. And again, if your attorney hasn't completed with trial, then we'll recall you for a different day. So you will be back on, let me see. Norma, put him down for November 3rd. We'll bring you back on November 3rd. And if your attorney wants you brought back sooner, he'll let us know. All right, thank you.
Okay, thank you.
Rogelio Favela. If you'll come down, please.
Good afternoon, Judge.
Good afternoon. Okay, Deputy Laura, you will appreciate this. The defense attorney who's on Zoom, I think their screen is from Harry Potter. All right. So who is the state on Rogelio?
Very good.
Hi. So where we are on discovery?
We do have all the evidence, Judge.
Okay.
Okay, Judge, this is interesting because I'm appointed on 2025 CR 10700, which is the case in court today. Mr. Mr. Favela on October 9th picked up a new case, 2025 PF 40266. On that case, he was appointed to Roberto Vargas.
All right, Norma, if you can make sure that Mr. Hopke is on the possession list in Graham case. All
Put me
right.
on both, okay.
All right.
And right now,
So has an offer been tendered?
no.
No, Judge, but I can give one.
All right. If you'll give an offer, please.
Okay. I'll also do a discovery acknowledgement.
All right. And Ms. Ferguson? I need a plea deadline date for the second week in April. I'm sorry, in November, please. All right. Your plea deadline date will be November 10th.
Judge, could that just be another court date? Because obviously I don't have anything on the new case.
The new case, I believe, is a state jail felony.
Yes.
All right. So we'll come back on November 10th.
Okay.
All right.
you.
Thank you. All right. Luis Andrew Medina III.
Downstairs, he is wheelchair bound and safe.
All right. We'll recall him tomorrow.
I can't, well, tomorrow I'm in Austin, but I can't proceed because I'm still waiting on evidence for the indicted family violence case. I do have evidence on the unindicted second degree CTD case. But
Family violence, where is his documents, his evidence?
It is uploaded, but again, I think we're having an e-discovery website issue that he can't see it, so I just told Mr. Hernandez if you can drop off a hard drive and I'll download all the evidence.
And I've explained to the state I can do that Wednesday since I'll be back in town on Wednesday. So I can bring that Wednesday if we can get him called a week or two.
All right. Deputy Laura, he's going to need to be here present in the courtroom. And this will be recalled for November 3rd.
Thank you.
Thank you. Isabel Arias. Hello, good afternoon. All right, so what is happening here?
It's our first setting, I think. As far as I can tell, all the discoveries in place, I have access to it. I have an offer. I'm asking both prosecutors from family violence and from CTD to inquire with the victim to see what range of punishment they're looking at or sort of punishment. So I can give that information to my clients.
Okay.
She's charged with 4 felonies. She's never been arrested before in her life. And she just had an incredibly bad day on this day. I'm trying to just get a better sense of what's at play.
All right, are there any mental health issues here?
She says no, but her affect indicates otherwise.
Okay. So you anticipate filing motions or?
I don't know, right? When I'm speaking to her, she seems fine, but I just want to dive in a little bit deeper at the jail.
All right, I need a 30-day reset for discovery, please. All right, and counsel, if you want to come back sooner than December 4th, just let us know.
All right, thank you, Judge.
So we'll bring you back on December 4th, but if your attorney wants you brought back sooner, he just needs to let us know. We'll have you brought back sooner, okay? Do you have any questions about anything? All right, thank you.
Thank you, Judge.
You're welcome. All right, Jimmy Vara.
Judge, I'm just waiting for a recommendation from the state on both of those cases on.
All right, so your client is in custody?
Yes.
All right, so you need to be in court.
Oh,
Yes, so have a seat. Your attorney will be here.
I'm sorry, Judge. Okay. And I also have Mr.
All right, you'll need to
They're
be in
both in
court,
custody.
counsel.
Michael Garza, they're both in custody.
Yes, so you need to be here.
Okay, thanks, Judge.
Thank you. Hi. You have someone else on the docket.
Oh, excuse me.
Yes.
Yes, my understanding is that he didn't show up.
All righty, so we need to put that on the record.
Yes, Judge.
All right. Court is calling 2025 CR 011324 State versus Richard Wayne Esquivel. Could I have parties announced?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 2:41 p.m. The defendant has not made an appearance. Deputy Laura, did the defendant ever appear outside?
No, Judge.
All right, defense, have you had any contact with your client?
No, Judge, and customarily what I do is I reach out as soon as I get the appointment. I've reached out several times to him. He's never responded to me.
All right, state.
We would be requesting a bond forfeiture at this time, Judge.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Hello, Mr. Simmons.
Good afternoon, Judge. I'm here. That was you, wasn't it?
Yes.
Okay, I'm sorry because I couldn't see the screen. I've spoken to Mr. Fish. We've been playing phone tag with his attorney in Terry County. Those charges sound like they're more serious. It seems like he missed court here in Bexar County because he was in the hospital. We have not received an offer from the state yet, so we haven't requested one, but he tells me, again, I haven't confirmed this with his attorney, so I'm going with him, but his attorney did call the office, so I have a number for his attorney, and I've been trying to reach him. It's just we're not sure what the status of his cases are in Terry County, and I don't know. He tells me that they're about to wrap those up, Judge, but I would think he needs to wrap those up before we can address the charges here. in Bear County. He also has some misdemeanor cases here in Bear County. I guess his previous attorney was Mr. Simpson. I'm not on those misdemeanor cases, so I'm not sure what the status of those would be.
All right, so
In
have
terms
you
of
had
this
a,
case, I guess it's the first time I've been able to meet with him. And we would defer to the court in terms of how the court would like us to proceed today.
all right, State, have you had a chance to speak with the defense?
I recall speaking to Mr. Simmons last week, but I'm struggling to remember what we talked about, so I'm trying to look up my notes.
All right,
It
so
was
if
not,
you all are,
Mr. Fish.
all right, so the state can join you in a breakout room. State, are you able to join him in a breakout room?
Yes, sir. I don't think I've had to do that yet. I've been here, so.
Oh, Ms. Ferguson will give you the link. And I'm sorry, Mr. Fish, if you'll go to breakout room number 1, and Mr. Simmons, if you'll stay in breakout room number 2. Or at least go back to breakout room number 2. And the state will meet you there.
That's my case, Judge.
Yes. Mr. Gomez, if you'll come down, please. Good afternoon.
Good afternoon.
All right. So what is happening with this case?
Judge, I've conferred with the state and my client. They've made us an offer. I want to go over some videos with my client. So we can get a reset to have the time to look at that and make a decision.
All right, Ms. Ferguson, if you can set this for the second week in November, please. All right, that will be your plea deadline date. On that date, you need to let the court know if you've reached an agreement. If not, your next setting will be a jury trial date. All right, thank you.
Thank you, ma'am. Thank you, Judge.
You're welcome. Anyone else ready? All right, the parties on Carmelita Tapia. All right, in probation, there are no applications. Good afternoon. How are you doing?
Good, how are you?
All right, cannot complain.
Long day. All right.
All right, the court.
Or do you need first now?
Court is calling 2024 CR 012738 and 2024 CR 011983. State versus Carmelita Christina Tapia. Can I have parties announced?
Lauren Espinoza for the state.
Juan Aguilera, attorney for Ms. Tapia.
And are you Ms. Tapia?
Yes, ma'am.
Counsel, have you received all discovery in each case and did you review with your client?
I have, Your Honor, and I have.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the true bill of indictment with your attorney? It shows what you're charged with.
Yes, ma'am.
All right, did you review those documents with your attorney?
Yes.
Did you understand them?
Yes, ma'am.
And counsel, in each cause number, do you waive the reading of the indictments?
We do, Your Honor.
State, in each cause number, are you proceeding on the indictment as presented?
No, Your Honor, in cause number ending in 3-8, we are waiving paragraph B and proceeding on count 1, paragraph A.
Any objection?
No objections, Your Honor.
In each cause number, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am. Yes, sir.
All right, in cause number 2024 CR 011983, you're charged with an unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number 2024 CR 012738, you're charged with collision involving serious bodily injury as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have plea bargain agreements with the state, the court does not have to follow your pleas. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering into these pleas, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and
Yes.
enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is, and she was judged.
Ms. Chappie, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering into these plea bargaining agreements, if you're not a US citizen, you will be deported, denied re-entry, and naturalization?
Yes,
Did you
ma'am.
understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. And each cause number, did you review the plea bargaining page with your attorney? Did you understand it?
Yes, sir.
According to the plea and the cause number ending in 3-8, state is proceeding on paragraph A, waiving paragraph B. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. No applications. The state will take in consideration 2024 CC 739662. And there's to be restitution, if any, to Boy Long, BAOLUONG. And the cause number ending in 8-3, according to your plea, punishment is to be assessed at 365 days in the Bexar County Jail under 1244. There are no applications, and this will be a judgment satisfied. In each of those cause numbers, did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
And cause number 2024 CR 011983, how do you plea?
I'm not guilty or not contest.
And in cause number 2024 CR 012738, how do you plea?
Not contest.
State any evidence?
Yes, Your Honor. In both cases, state offers states exhibit 1 in all attachments, and then also for the court's knowledge, there are some photos in the stipulation.
No objection, Your Honor.
All right, and have you had a chance to speak with the complainant?
Yes, Judge.
All right, thank you.
Thank
Maybe excuse. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
In each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. In each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea bargain, Your Honor.
All right, and cause number 2024 CR 011983. The court is finding you guilty. The court will sentence you to 3 years in the prison. Give you credit for any time served. There's a $1,500 fine. Take in consideration 2024 CC 739662. There's to be restitution, if any, to Bao Long. And do you have any children?
I have two kids, 2 boys.
And who are they with now?
My baby's dad, my baby's father.
All right, and there's to be no unsupervised contact
Yes, ma'am.
with minors.
Yes, ma'am.
And based upon what I read in the police report, I'll recommend the therapeutic community. It doesn't increase the time that you're in custody, but if you have a drug or alcohol problem or mental health issue, it will help you with that. Is there anything else with regards to sentencing under that cause number?
No, Your Honor.
Deputy, I'm sorry, Cindy.
Yes.
What cause number did I read that for?
You said, that was the 11,983, and you took into consideration the 739,662.
All right, there needs to be a correction. So that sentence is actually in cause number 2024. CR 012738. And I'll state it again so there's no confusion. So under that cause number, the court is finding you guilty, 3 years in the prison, credit for any time served, a $1,500 fine, taking consideration 2024 CC 739,662, restitution, if any, to Bao Lung, no unsupervised contact with minors in the therapeutic community. And then in cause number 2024 CR 011983, the court will find you guilty and the court will sentence you to 365 days in the Bexar County Jail under 1244, give you credit for any time served, and the court will show that the judgment is satisfied. All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes.
you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Because these are plea bargaining agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you, okay?
Thank you.
You're welcome.
Yeah, big sure.
Yes. Mr. Simmons,
I'm sorry, Judge.
what is occurring on this case?
I've conferred with the state. There's still some. It seems as if this case got a little lost in the shuffle. Of course, he had previous counsel. The state was saying that they still wanted to get some additional discovery. They did get the police guide. They did convey an offer. I will. I've conferred with my client, and I don't anticipate it's something he would accept, but I have not conveyed it to him specifically in terms of him rejecting it. So I don't know if the court wants me to do that quickly before, but it seems as if probably he also needs to see the case, the charge that he's dealing with in Terry County as charged seem to be more serious offenses, and so I'm not sure how long he's going to be there in Terry County either, Your Honor.
All right, Ms. Ferguson, I need this reset for the 3rd week in November, and that will be your plea deadline, counsel.
If I could be placed back in a breakout room with him so I could convey that the offer to him, and then take it from there, Judge.
All right, what date?
The 18th.
All right, so we'll be back on November 18th, and I will place you back in the breakout room with your client.
Thank you, Judge. May I be excused from that
Yes.
breakout room?
Yes, but well,
I'll
come
come. Okay, then I'll come back.
because I'll need to make sure that he is back and let them
Yes, Your
know.
Honor.
Well, you know what? I'm sorry. I'm being a little bit indecisive today. This is what you can do. Once you finish speaking with him, just have him get the deputy from there and let that deputy know that he's going to be recalled back on November 18th.
Yes, Your Honor.
And then they can have him excused from the breakout room.
Okay, Your Honor.
All right. And Norma, that'll need to
Nope.
be by Zoom. Court is calling 2025 CR 012107, State versus Shane Collette for the state.
Lauren Espinoza.
All right, this hearing was scheduled at 9 a.m. It is now 3:18 p.m. Defendant had not answered docket. Deputy Laura, did you make an announcement?
Yes, sir.
All right, we're here on a violation report. And previously for the violation report, the court gave the defendant many attempts to get into compliance with pretrial services. He has failed to do so. He is currently on a PR bond. State?
Your Honor, we would ask for a bond forfeiture.
All right, the court will issue a judge's warrant and remand him without bond.
Thank you.
Thank you. All right, the court is calling 2025 CR 011376, State versus John Isaac Cepeda. Could I have parties announced for the record for the state?
Laura Espinoza.
For the defense?
Greg Desmarais. Good
right.
afternoon, Judge.
Good afternoon. This hearing was scheduled at 9 a.m. The defendant did not answer the docket. Deputy Laura, did you make an announcement?
Yes, I did, Your Honor.
All right, defense, have you had any contact with your client?
I haven't, Judge. I was asked to take care of this case 2 weeks ago. He got out of jail. I did go down to County Court 14. He has a pending case there. They told me that's not set till November 17th. I came back to court. I didn't see him in there. And so I'll keep trying to reach out.
All right, state.
We would ask for a bond forfeiture at this time, Judge.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you.